Welcome to the Lawsome Sauce Podcast, your go-to for unraveling the most intriguing legal cases shaping the world around us. I'm PJ.
And I'm Harper. Our special guest today is Maia Aron from Migdal and Hayden. Maia's practice is complex commercial litigation, and she is also skilled in receiverships and aims to do special master work in the future. Welcome, Maia.
Hello, everyone. I'm so happy to be on your show. I have worked as a court-appointed receiver, and I think the case you have chosen to discuss today is fascinating.
Thank you, Maia. Let's get started with the background of the case and come back to Maia for her perspectives later in our show.
Sure thing, PJ. Today we're traveling back to post-war Miami, 1949 to be exact, for a case that blends family drama, hotel management, and the delicate power of equity in McAllister Hotel versus Schatzberg from the Supreme Court of Florida.
This one's a civil procedure classic. It all starts with the luxurious McAllister Hotel, a prime piece of real estate in downtown Miami that became the subject of a bitter power struggle between business partners and their families.
Here's the setup. Herman Schatzberg secured an option to buy all the stock in a corporation that owned the McAllister Hotel. Lacking the funds to follow through, he teamed up with a wealthy investor, J. Meyer Shine. Together, they formed a new corporation called McAllister Hotel, incorporated, with Shine supplying the funds and taking voting stock. Schatzberg's stock was non-voting.
It wasn't long before things turned ugly. Schatzberg's wife and daughter, Frances Schatzberg and Rita Feinberg, filed suit alleging mismanagement, self-dealing, and corporate misconduct by Shine. They asked the court to appoint a receiver to take control of the hotel's assets.
The trial court agreed, appointing a receiver, pendente lite, essentially freezing the hotel's control mid-lawsuit and handing it to a neutral party. But Shine and his co-petitioners weren't having it. They filed for certiorari, asking the Florida Supreme Court to quash the order.
So what was at stake here legally? The key question is, when is it appropriate for a court to step in and take control of a company's assets before the case is even decided?
Receivership is considered a drastic remedy. It's not supposed to be used just because things look messy. According to long-standing Florida precedent, courts should only use it when there's no other way to protect the parties involved.
And that's exactly what the Florida Supreme Court emphasized in its ruling. Let's break down their reasoning. First, the court noted there was no evidence of insolvency.
Shine, the alleged wrongdoer, was described in court as a fabulously wealthy man. And that mattered. Because if someone's solvent, the court can still order financial remedies later without needing to take control now.
Second, the court found that other tools were available. Injunctions, for example, could have stopped further payments or corporate decisions in question without freezing the whole operation. In other words, there was no need to go nuclear.
Third, the plaintiffs, Schatzberg's own family, weren't exactly outsiders. They'd received their shares as gifts and had participated in decisions they later claimed were improper. In equity, your hands can't be dirty.
That's the doctrine of unclean hands. A principle in equity law that says if you've acted unfairly or in bad faith in relation to the matter at hand, the court may refuse to help you, even if you have a legitimate complaint. The court also stressed that the alleged misconduct, like overpaying management fees, claiming inflated debts, and operating at a loss, could all be addressed through accounting or damages. That didn't justify putting the hotel into receivership.
So in the end, the Florida Supreme Court quashed the order appointing the receiver. The takeaway: courts must be exceptionally cautious when appointing a receiver, especially when parties are solvent and the alleged harm can be addressed in other ways.
It's a decision that remains relevant today, especially in complex business disputes. Receivership may sound like a protective measure, but it's heavy-handed and expensive.
Let's bring in our guest. Maia Aron is known for her deep experience with complex commercial disputes and receiverships. Maia, how do you view the court's reluctance to appoint a receiver in this case?
What stands out to me is how the court balanced the equities. The court did not deny that there might be some wrongdoing, but the court emphasized that the purpose of a court is to do no greater harm. Receiverships can feel like a logical step when there is waste, but the court held the line. Solvency matters, alternatives matter, and fairness cuts both ways.
So in your opinion, was the court right to quash the receivership?
Yes, I believe that in this case they were. There were other tools on the table, and the court sent a strong message. Just because a court can appoint a receiver doesn't mean that it should, especially when the harm is speculative or preventable through less drastic means. However, the court also noted that a receiver is appropriate and necessary where there is actual fraud or mismanagement amounting to fraud upon the rights of a minority stockholder or creditor which seriously threaten the corporate assets. In those cases, a receiver can save the company and its assets so that they're there once the dispute is resolved.
Thank you, Maya. That's helpful context. So here are today's takeaways.
1. Equity powers like receivership are not just tools, they're last resorts.
2. Solvency changes the game. If the accused party can pay damages, the urgency for court control diminishes.
And 3. Courts won't reward parties who come to equity with unclean hands, especially when those parties had knowledge or involvement in the disputed conduct.
That's all for this episode of Lawsome Sauce. If you've got a case you want us to dissect, drop us a line. We're always on the lookout for legal stories that challenge, teach, and surprise.
And remember, while we love discussing the law, we're not your lawyers.
For legal advice, you should talk to a lawyer.
Nothing we say should be construed as legal advice.
And anyway, you should never take legal advice from kids.
Thanks for tuning into the Lawsome Sauce Podcast.
Until next time.
Stay curious and stay informed.
Have a great day, everyone.